We're getting closer and closer to the 29th of May when that all-important vote takes place, and the Constitutional Court is today hearing the IEC's appeal seeking clarity on former President Jacob Zuma's candidacy for Parliament. It follows an Electoral Court ruling overturning the body's decision, halting him from appearing on the ballot for the MK party. This is due to his 15-month contempt sentence. The former president has asked 6 justices to recuse themselves due to alleged bias. My co-anchor, Aldrin Sampear, is outside the Apex Court and joins me now live. Aldrin, a good morning to you once again. Have we started to see the arrival of supporters? And perhaps explain to us just the security detail that you see outside of the court as well.
Well, as it stands now, we haven't seen any political party members and supporters of the MK party that have arrived here, but we are told by the JMPD that they did bring an application together outside the Constitutional Court on Constitutional Hill, so nothing as yet. There are a number of police officers that are gathered here, perhaps in anticipation that there could be a number of people who would be coming who have interest in this matter being heard here at the Constitutional Court. I just quickly want to bring in Macbeth Ncongwane once again, who is our legal analyst today. He is an attorney. Macbeth, I want to now look at the papers that have been submitted by the MK party, or the papers that have been submitted on behalf of former President Jacob Zuma. In the submission, there's also this issue that is now being brought back that the Electoral Court has already dealt with, in that the powers of the Electoral Commission when it comes to barring certain individuals to stand for an election. And paragraph 78 of that application of the counter application and cross appeal, this is what the argument is. In short, eligibility of membership of the National Assembly is not equivalent or synonymous with the qualification of candidature in the elections. These two concepts serve two distinct yet potentially related purposes. What do you make of this?
Now that it's part of their cross appeal, I think they are entitled to bring back that argument, because if it was possibly rejected by the Electoral Court for the reason that to say, look, the Electoral Court indicated that absolutely the IEC has all the powers and the jurisdiction to deal with barring candidates that are not eligible to participate in elections as well as going. Because you must understand, Aldrin, that could you just imagine a situation whereby they say if you are a delinquent, you cannot be a member of a company. Then the argument be that, no, look, allow me to be a member of that company. If I happen to get a job in another organization, those are the ones to raise the issue of eligibility to be a member of this company. So it's very similar to that. So IEC served for that purpose, and Section 471E was literally meant for that lawbreakers should not be lawmakers.
Yeah. And that's the argument that they're making in the papers as well.
Yes. So I'm only going to allow, if I may allow that kind of an argument to flourish in this court, so that at least we get a directive, a proper directive, this being the Apex Court.
Yeah. One of the issues that Professor Modiba also raises in his judgment, this is now from the Electoral Court, is that he would have wanted the applicants to bring more submissions before the court, but because of the pressure in relation to the matter that is now before the Constitutional Court, and also that they had to hand down judgment. What do you make of that particular conundrum? Because the application before the Constitutional Court came even before the judgment itself was handed down.
Yes. I mean, that tells you exactly the conundrum, that look, the judges did not fully apply their mind in the issue. Because judges, when they are faced with certain difficulties in the papers, they can issue directives for further heads of arguments on a certain clarification of a point and that. And if Judge Modiba is saying this, it's actually loaded. It tells you that there was no sufficient time to really ventilate the matter. So now that it is here in the Apex Court, and I suspect the same prejudice will be there. In 2 weeks' time, we are going for the elections. A decision must come out as soon as possible, coming from this Apex Court, to actually deal with and clarify all those issues which Judge Madiba raises in her judgment.
Yeah, just a quick one. We're at the Constitutional Court, and the first black women justice of this court sadly passed on yesterday. We heard the sad news. Just quickly, your condolences.
I've known and understood the role of Judge Mahoro when I was still a law student. And she comes up as an epitome of transformation because it's for the first time a township black woman ascends to this highest position ever in South Africa. And it was the commitment of the new constitutional dispensation and the government of South Africa to show that we are all equal. Women can play the very pivotal role in addressing issues of the law, first of all, because remember, she was the Constitutional Court judge and also she was the chairperson of the South African Law Commission. And that is loaded. It tells you how serious the South African government took the issue of transformation.
Macbeth, thank you so much for your time. Indeed, Naledi. And I was actually watching an interview yesterday that Justice Mahoro had. And in that interview, she speaks about how she decided to become a lawyer or later on a judge. And that was because of Robert Sobukwe, who actually represented her in one of her matters before a court where she was accused of obstruction of justice. And since then, she's never looked back.
Yeah. And what an example she certainly was. Aldrin Sampear there, my co-anchor, who is outside the Constitutional Court, keeping us updated on that upcoming legal battle between the IEC and the MK party in the Apex Court.